Welcome to the F&J podcast, where we bring you inside the courtroom and beyond the headlines and into the cases that are shaping the future of personal injury law. From product liability to severe accident cases and headline trials, each episode delivers real stories, real cases, and real insights from the front lines of justice. Whether you're someone who's affected by a faulty product, a legal professional, or just someone who's interested in mass tort litigation, this show is for you. A small disclaimer. All information shared on this program is for entertainment purposes only. It should not be taken as legal advice.
All right, so I am with one of our attorneys, Mr. Rand Nolan, the Rand Nolan, not to get confused with any other Rand Nolans.
Right.
Definitely very knowledgeable, one of the leaders of the firm. If we have any questions, Rand's usually the guy that we go to. Just recently finished a trial.
Right.
So that's exciting. How do you feel about the outcome of that trial?
Well, we don't have an outcome yet. So the Addicks Barker litigation has been going since 2017 when the Addicks and Barker reservoirs west of Houston were opened by the Army Corps of Engineers and flooded Buffalo Bayou corridor, which is the area that runs along Buffalo Bayou on both sides. There's a lot of houses and commercial development in that area. And so when they opened the reservoirs up, they released 125 billion gallons of water downstream, and it started pouring out at 13,800 cubic feet per second into an already swollen bayou because of the runoff from Hurricane Harvey. And during that period of time, all of those homes that were downstream along Buffalo Bayou were flooded.
What were the most significant challenges that you faced with this?
So this particular case, the biggest challenge has been just the large amount of evidence that's involved in the case. We had to gather evidence for a couple of years. We did over 40 depositions for the trial, reviewed 550,000 documents, and had to bring all of that into some sort of form where we could present it in a cogent and coherent way to the court so that the court got the answers to the questions that it was looking for.
So then I guess factoring in all this massive amount of evidence, what argument are you kind of coming with when you're trying to formulate this?
So this is, again, a case in the Court of Federal Claims, and the underlying allegation, the thing that drives the potential recovery in the case, is that when the Corps opened the gates and flooded the downstream corridor or inundation corridor, whichever you prefer, when they did that, that constituted a Fifth Amendment taking. So a takings under the Fifth Amendment of the United States Constitution. Under the Fifth Amendment, if the government takes your property, you're entitled to just compensation. When they flooded those homes, there was a temporary taking during the period of time that the water was moved out of the reservoirs and into the downstream homes, because the homes themselves were not habitable during that period of time. There was destruction of the property, both the personal contents and the improvements on the real property. And then ultimately there was a taking of a thing called a flowage easement. And under the Department of Justice and the Army Corps of Engineer regulations, if there is a flowage easement that has been created, that area is uninhabitable because the water displaces anything that is there. And so arguably they took a flowage easement that is permanent, given that they can do it again at any time. They can flood that area after heavy rains fall and fill up the reservoirs. And two, the homeowners have zero control over whether that occurs or not. So
it's like no vote or anything like that.
Nobody consults with them. They just simply
just do it.
Manage the reservoirs the way they see fit, And when they do that, they can open the gates at will, which is what they did in this instance. They followed a thing called the Water Control Manual, which is a standing order that is contained in a multi-page document that tells them how to manage the reservoirs. And so when the triggers were met for a thing called induced surcharge, that's when they opened the gates. In preparation for the landfall, the Army Corps of Engineers closed the Addicks and Barker reservoir gates in order to collect the water from upstream so that it did not flow into the Buffalo Bayou and flood the homes downstream. Once the reservoirs started filling up and they reached these trigger points for something called induced surcharge, then under the regulation that's contained in the Water Control Manual, the Army Corps opens the gates, and that's what they did. They opened the gates, and when they open the gates, the water comes pouring out. And I mentioned earlier 125 billion gallons of water flowing through the gates at 13,800 cubic feet per second. And it all goes into the bayou. And so at that point, the protection that the downstream homeowners along Buffalo Bayou were receiving before by virtue of the reservoirs themselves, well, that all goes away because now the gates are wide open. Water, which had been housed in the reservoirs themselves, is now being released, and it's moving from the reservoirs into people's properties downstream.
Okay, so you're saying, all right, so you have public takings. What are they saying as the counter argument for that?
One of their defenses is that this particular event was a giant act of God that they had no control over, which was a massive downpour of rain into the watersheds known as the Addicks and Barker watersheds, and that they had to open the gates because the amount of rain that had been collected behind the reservoirs was such that if they didn't open those gates, that over time it would cause some sort of damage to the structures themselves, and it also was backing up water into upstream properties, and that's a separate lawsuit by the upstream homeowners who were flooded as a result of the amount of water collected in the Addicks and Barker reservoirs.
Interesting. So then, when you heard that, did that change your strategy at all, or?
No, it didn't change anything because the evidence and the facts in the case are that the Water Control Manual has had this induced surcharge provision in it since 2012. All it says is that once you hit a certain amount of water behind the reservoirs and there is a certain amount of rise, so the volume of water and the rise inside the reservoirs, when that hits a certain level, it triggers the opening of the gates. A computer would do it if it was set up that way. In this instance, it was physical human beings who did it. But they just simply followed the regulation. And so the regulation, as written, contemplates flooding the downstream properties. Well, if you write a regulation that contemplates the destruction of private property, then that is something you know about. It's not an emergency. You simply have factored it in. And so it's part of the manual, it's part of the normal operation of the reservoirs themselves. And so once they went into induced surcharge regulation, which meant they opened those gates and let that water flow out, they knew exactly which properties were going to be damaged, which ones were going to be taken to move the water out of the reservoirs and into those properties. And when they did that, they took the properties. Now, they could have said, well, we've got this 2012 regulation called induced surcharge. We have these models and this mapping. It shows us exactly which properties will flood, which it did. And they could have gone and bought a flowage easement from each of those property owners. And what that would have entailed was going along Buffalo Bayou and buying the properties on either side of the bayou that would flood once they opened those floodgates and induce surcharge. They chose not to do that. They had every ability to just simply go and purchase those properties, and the homeowners would have moved, the property owners would have left, they would have demoed the structures, and that would have been it. And then there wouldn't have been this litigation, because the water would have been able to go down the Buffalo Bayou channel. It would have gone into the thing called Buffalo Bayou. It would have come up over the banks of Buffalo Bayou. It would have flooded the now vacant land on either side of Buffalo Bayou, and it would have flowed directly into the Gulf of Mexico, which is where it ends up anyway.
That's interesting, because I was thinking about that too, and I think that's a very logical solution that they could have easily exercised. But the other thing I was thinking is, for something like that involves private property, I'm surprised that this wasn't like a proposal that was brought up during an election time. Since you're involving private property, people would have a say in, like, hey, in the event of a flood, do you guys vote that we can essentially destroy your property?
So what you're saying there makes a lot of sense. So the Department of Interior and the Army Corps of Engineers regulations, going back to 1966, says that it is the policy to buy all of the property in a surcharge corridor, and so. Going back to 1966, had they followed their own regulation, they would have bought all of that property in this thing called the surcharge corridor, which again is the properties adjacent to Buffalo Bayou. And they didn't do that. And what they did is they studied. They studied how much it would cost to buy up that property, and in the 1960s they determined, well, gosh, this is really expensive. We don't want to spend that money. Congress doesn't need to allocate that money. So they didn't. They studied it again in the 1980s, came to the same determination, except for this time, of course, the properties were much more valuable. And they decided not to spend that money then. They did in the late 1990s. They studied it again.
Were they hoping it would get cheaper over time?
Well, they decided, it's really, really expensive. And
it's just going to keep getting more expensive as time progresses.
There's really no budget for that, and we haven't asked for a budget for that. And so nothing happened. Yep. And the elected representatives of West Houston, which was a representative named John Culberson, a Republican who had represented District 7 for years and years and years, and his predecessor, Phil Archer, did not do anything. And you can go all the way back to George H.W. Bush, who also represented that district. None of those folks ever saw fit to bring forth funding to purchase that land, that property. And, in all fairness, this opening of the gates and having this much water in the reservoirs had never happened before.
Yeah.
So there had never been an induced surcharge previously. There was some debate about whether it would ever happen. And they put the regulation in the water control manual in 2012. They had a manual prior to that went back to 1962 that had sort of a similar regulation, but not exactly the same. And during that entire time, nobody ever saw fit to allocate the funds to go and buy the properties.
Yeah.
And so our position is this is something that was not unknown. It was predictable. If there was ever going to be an instance where you had that much water collect behind the reservoirs and you had to open the gates and go into induced surcharge, they knew with exactitude which properties would flood downstream because they spend millions of dollars modeling that and getting an understanding of which properties would flood, and they chose, and it's a conscious decision, not to address the issue.
Yeah.
And so our position is that if you know that you're going to take people's property when this thing called induced surcharge comes up or comes into effect, into being, then you should go and purchase those properties so that you don't create downstream the massive flooding that occurred and caused all of this damage. They had every opportunity to do it, and they didn't do it.
So what are the next steps from here?
So once we present the rest of our case in Washington, D.C. in early December, we will, as I mentioned earlier, we will have a briefing that is an adjunct to what the court has now seen in the trial. And then we will have a closing argument, probably not a real long closing argument. I would suspect 40 minutes per side, probably, not super long. Court has now sat through the trial, will have seen a lot of briefing at this point, should have a good grasp on the facts. And in fact, unlike state court cases, federal judges can ask questions of witnesses while they're on the stand. And Judge Smith availed himself of that ability throughout the trial. He obviously, I think, has a very clear understanding of what the issues are.
What has been the real impact of this? Especially now it's like we're running into 7 years since the incident.
Yeah, it's a massive impact. And so all of those folks that were flooded, they didn't get a foot or 2 feet of water in their house. They got 4.5, 5 feet. Some places, when you get far enough downstream, some places had 7 feet of water in the house. It sat in the houses for more than 20 days or right at 20 days. That's a level of damage that short-term momentary flooding that you might get in Houston, Texas, this is a level of damage that it goes well beyond that.
Yeah.
Every single thing was saturated to the point of complete and utter destruction. You even had damages to framing as a result of the amount of water that was sat standing in these homes for a very long period of time. So all of them suffered really massive damages. These homes were, some of them could be salvaged, some were total losses that were knocked down. All of the furnishings inside the homes were destroyed beyond any kind of repair. And for a lot of folks, it was a financial burden and hardship. One, they were out of their homes for that period of time. They had to come up with some cover for themselves and their families. The federal government did help. FEMA did help, and so they did get some relief on temporary shelter. Then the federal government made loans through the Small Business Administration available, low interest loans, so that they could build back these homes. People ask all the time, well, gosh, didn't they just have flood insurance? Didn't they just take care of everything? The answer is no, because most of these homes were not in flood zones. They weren't required by mortgage companies to have flood insurance. Many of these folks had lived in these homes for 40 years and never had any flooding at all. And so if you take it from the perspective of a retired fixed income individual, even if that individual lives in a home that cost $800,000, they've lived in that home for 40 years. They paid off the note. They owe no money on it. And they're in their house. They're secure that it's never going to flood because it never has flooded in all the years that they lived there. And so they're going along with their lives. They don't have a mortgage. They just have to pay their taxes. They have to pay homeowners insurance, which does not cover flood. And they don't even buy flood insurance. They're not required to. Nobody's making them. They've never had an experience of flooding, so they didn't. And so here comes this flood. Now you're 80 years old or 75 years old. Your home is completely destroyed. All your belongings are completely destroyed. That's what happened. And you were evacuated from your home after the flooding occurred by canoe. So you were in a canoe, being canoed out of your home that you've lived in for 40 years. It's completely and utterly destroyed. You show up after 20 days into these wet, soggy, saturated home. The only repair that can occur is to take it down to the studs themselves and start over. All the flooring is destroyed. All the drywall is destroyed.
Let's make a whole new house.
That's right. Some of them chose to do that, who had the wherewithal to do it. Others chose to try to salvage what they had. They had everything ripped down to the studs. All the electrical had to be replaced. Air conditioning units had to be replaced. Water heaters had to be replaced. Any gas, anything had to be replaced. All of that was destroyed. So they start over. Well, if they were independently wealthy, which most of them were not, even though they had nice homes, they took out these loans that the Small Business Administration provided that were at a very low interest rate, 2%. But you're 75 years old and you're signing on to a loan that you're going to have for the next 10 plus years, and you may never get to the end of that loan.
Yeah.
And that is money that you had in the bank that every month you're making payments now on a loan on a house that you paid off 20 years ago. Well,
I thought you were.
Yeah, you thought you'd done good.
Yeah.
And this is what you end up with. It was a horrific experience. And it was not just a horrific experience for one of them, it was a horrific experience for every single one of them. Nobody, we've had, in the 7 years this case has been pending, we have watched a number of the clients die. And so, they spent the final years of their lives having construction in their homes that were paid for, and then moving back into the home and only getting to live there a few years while they made those payments, and then passing away. So these golden years that were supposed to be carefree because they had insured their own financial future and they'd paid for their home and they had a shelter that they could count on. They did everything that you're supposed to do as a responsible American, and it was really disrupted. And for some of them it was a nightmare. Others who had more wherewithal, more financial ability, it was less disruptive, but still disruptive.
Would you like to see any policy changes? If you had the way to make any adjustments to the Corps of Engineers' way of doing things, would you be able to would you advise them to make any changes to the procedure?
So the first thing to note about all of that is the Corps is our government, it's the Army, and they're not bad people. We never said they're bad people. In fact, they're good people. They do great work around the world. Army Corps goes all over the world building projects on bases, building projects in the interior of the United States. They do tremendous work. So nobody is saying they did anything wrong. They followed the regulation that was in place, not criticizing them for following the regulation. We know that's what they did. Where there has been a disconnect is in 1966, as I mentioned, the regulations that the Department of Interior adopted and the Army Corps adopted, a policy going forward of purchasing homes that would flood in a surcharge release. And this is exactly what induced surcharge is. It's a surcharge release where you release water that you have impounded because you need to release it for whatever reason. In this case, it was because the regulation said so. They didn't determine that the reservoirs were about to fail or there was going to be an imminent failure of the dams that are attached to the reservoirs. None of that. That did not occur. In fact, we nailed that down multiple times, multiple witnesses. This was never a situation where they were worried and concerned that those structures were going to come apart and were going to fail and cause catastrophic flooding all over West Houston. That was never in the equation. Instead, what they did is they followed the manual as written, and they did exactly what they were supposed to do. All we ask is that government do what it decided it would do back when President Lyndon Johnson was in office, which is buy the properties downstream that would be flooded in a surcharge operation. And so if I could change anything, I would tell the Army Corps of Engineers, and I would tell the Department of Interior, and I would tell DOJ not to continue with this type of litigation anywhere. Instead, just go and buy the properties up the way you were supposed to back in 1966.
Well, I do appreciate you taking the time, your busy schedule, to talk with us. If you have any further questions, you can always reach out to our office, or you can go to our blog. We have, Rand has written a nice piece to kind of inform our current clients, but if you also happen to be interested, you can go and read more about that there.
Well, I'm happy to do this, and we strive, since I'm one of the appointed leadership in the Harvey litigation, in the Addicks and Barker litigation, we service and serve not only our own clients, but anybody who has a question. If you call, we try to address it. If you already are represented by an attorney, we're not asking you to dump your attorney. We were appointed by the court to represent the interests of all of the downstream property owners and victims. And so we answer questions, and that's what we do.
All right, thank you. See you next time.